And section 16 says, suppose somebody claimed multiple inventions, then there are some procedures. According to section 16, power of controller to make orders respecting division of applications. Suppose you applied multiple applications in a single application, multiple inventions in a single application, then controller have to power to make some orders to divide your application into two. That is section 16. Any time before the grant of a patent or further application, it is known as divisional application, may be made out of an application already filed in order to overcome the controller's objection of multiple inventions. We are already discussed that suppose you submitted a request for examination, it is the duty of the patent examiner to conduct the investigation whether your application is submitted according to the Patent Act and rules. Suppose there is a finding that you applied multiple invention and it is against to section 7, then according to section 16, controller shall direct you to divide your application into two. And one application may be treated as principal application and the other application is known as divisional application. In short, you have to divide your application into two. The concept is clear?
Yeah.
Yeah. For example,
Yes, sir.
yeah. What happened was one of my client, it was an old story. He filed an application for rat trap. And normal rat traps, you are all aware that majority farmers are using catch the rat. The conventional cage is there. And the problem is after catching the rat, you have to kill the rat. It is very difficult for the people. And according to the new invention, this particular device can automatically kill the rat without blood. There is a device like hammer and other things. And the size of the device is also very much important. Normally, suppose you catch the rat in a conventional box, the rat may urinate there, and then suppose the smell is there next day, the other rat avoid the cage. And according to this invention, suppose the rat is urinated, it may be out of the device. Means there may not be any urine smell. That is the another advantage of this particular device. And along with this, he also invented an advanced rat trap system applicable for go downs, etc. Means automatically you can kill multiple rats. That is the advantage. And we filed a single application for the same. And there is some difference for the device for the domestic purpose and for the industrial purpose. When we got the FER, first examination report, there was an objection according to section 7. The main objection was, according to the examiner, this device is two. One is for purpose for the domestic rat trap and the other is for industrial purpose. And our inventor also got a very interesting result also. One day what happened was he want to conduct some experiment with the domestic work. And then he approached one departmental store and he requested to keep for one night inside the department store. Initially, the department store owner objected because we don't have any rat. And after a discussion and at last he allowed that for experiment purpose, you can install in our department store. And what was happened the next day when he opened the department store, this rat trap, this is an automatic thing and there is a storing system also. He got 167 rats inside the device. And what was happened in this case, according to section 16, we filed an application for the subsequent one. The domestic rat trap we maintain as the principal application, and the automatic use for the departmental stores or the godowns, etc. We divided and we got another number. We proceeded according to section 60 by directed by the controller. I think now the example with the example, the concept is clear. Okay. The divisional application, the subsequent application is known as divisional application. The divisional application as per subsection 1 shall be accompanied by a complete specification but shall not include any matter not disclosed in the specification of the principal or parent application. When we submitted the application, we already drafted a complete specification related to one invention for two devices. Means according to our drafting, we have some additional claims, some improvement in the same concept. In our opinion, the concept is same, but device some parts are different. And this subsection 1 says shall be accompanied by a complete specification, means subsequent to this objection, we have to submit a fresh complete specification for the application industrial purpose, the rat trap for industrial purpose. And but shall not include any matter not disclosed in the specification of the principal application, means at that time we are not able to incorporate any new facts because the invention is already submitted. We have a priority date for the same. Now there is an objection for against the multiple claims, multiple inventions. That is why we are forced to file an application, a division application, uh, immediately after getting the response of FER, first examination report. That was the real matter that happened in our case.
Sir,
Sir,
I
one
have a
thing.
question.
Yeah,
Yeah. So, sir, for example, if there is a material,
yeah,
okay, and the material, the raw material, the core material is so flexible that
yeah,
if you change the additives, it can be used for various applications.
yeah,
Okay. So then in this case, it is just one invention, right?
yeah,
It won't qualify as divisional, right?
yeah. That yeah, you are correct.
Yeah.
You are
Okay.
not claiming multiple inventions in your example.
Yeah. So you're claiming just one material, which can be by using different additives, it can lead into different end products.
Yeah, but
So the
your
claim is the material itself.
main invention is same.
Yeah, yes, sir. Yeah.
Yeah, it cannot be a tracked under section 16.
Right, sir. Okay. Thank you.
Yeah, okay.
Sir, sir, one question.
Hmm.
The priority date of the divisional is same as that of the main application, or it has a
Yeah,
different
yeah,
priority?
same.
Uh,
Because you are already disclosed and published your application. Examination is only after publication. Suppose it is publication, you are already losing the novelty concept. then you have to claim priority according to your date of parent application.
Okay, sir.
That is most important, that priority question. Okay. Next is, the controller may require amendment of the complete specification filed in pursuance of either the principal parent application or the division application, as may be necessary to ensure that there is no repetition of any matter claimed in the other. Now you are dividing your application into two. Suppose you are claiming some part, you are not allowed to repeat the same points in the previous parent application. Suppose I am filing an application for the rat trap for industrial purpose. I have to cut and paste the relevant part only. Whatever relevant for the domestic rat trap machine, you have to retain in the parent application. That is why it is very clear that the controller may require amendment of the complete specification filed in pursuance of either the principal application or the division application may be necessary to ensure that there is no repetition of any matter claimed in the other. Explanation says the division application shall have the filing date of the parent application, your question, the priority date, and proceed as a substantive application and shall be examined upon filing a request for examination as per Rule 24B1, Clause 4. Subsequent application, the priority date shall be same, but the condition you have to request uh, for examination separately. You have to submit Form 18. That is important.
Sir, I have a question.
Yeah.
Whether division application is examined at the same time at the main examination or after the main examination, main application.
Your question is not clear for me. Please repeat.
Whether the division application is examined at the same time as the main application or after the main application.
After the main application only. According to the applicant, it is a single invention. When you filed a request for application, at that time examiner objected that your application is coming under multiple inventions, and accordingly you are submitting a division application, and the division application you have to file a separate request for examination, and you have to, according to section 16, you have to divide your application into two. One application you can treat as a parent application. In parent application, you are already submitted request for examination. And the subsequent division application, you have to submit a new request for examination. The procedure you have
Okay.
to follow.
Okay. Sir, one
And
question.
you are getting a new number for the division application, but the priority date shall be the same.
Okay. Sir, one question. Normally, request for examination, they need to be filed within 48 months from the
Correct.
priority date.
Yeah.
Now, since the first application has already been done like that, the second one, that is the divisional one, I mean, it might have crossed 48 months, right? But still, RFE will be valid. So,
In that case, you have to follow section 21. According to section 21, you have to submit the response within 6 months.
mhm.
That 6 months may be extended 3 months more. Means you have to comply because you are getting FER on the basis of section 21. Okay. There may be two chances. Suppose you got the examination report in 30th month, you have sufficient time. Suppose you submitted the request for the original application on 48th month, then there is no time for filing application request for division application. In that case, you can use, you are complying the FER within that particular time provided by section 21, and within that stipulated time period, you have to file the division application. Along with the application, you can file a request for examination also. Clear?
Okay.
Clear?
So, so sir, if there is no time, then in that case, like, I mean, combine the divisional, like submit together the divisional along with the FER response.
Yeah,
That's what you mean to say.
because this is a prosecution of your application. You are already got a number, and your application is already published and examined. Means
Yes.
proceedings are going on. And to rectify the objection according to section 16, the section 21 is applicable. According to section 21, you have to submit the response of your FER within 6 months. Means within 6 months, you can file the division application, and along with the division application, you can also file request for examination. 48 months is over, but no problem, because this is proceedings of your parent application along with the parent application. That is why you are also getting the privilege of the previous priority date also. It is not a new prosecution. It's a part of the your prosecution of your parent application. Clear?
Yeah.
And this is related to subsection 4 of section 9. We are already discussed that the post dating, power of controller to make orders respecting dating of application. The controller may, on request of the applicant, direct the application post dated to a date as requested and proceed therewith accordingly, provided that an application shall be post dated to a date maximum up to 6 months from the date on which it was actually made or would deem to be have been made. Suppose your priority date is January 1st and your expiry date to submit the complete specification is 31/12 December 31st. Suppose your the provisional specification, your complete specification is not ready. The consequence is, according to subsection 1 of section 9, your application may be abandoned. You want to avoid that. In that case, you can make use of the provision under subsection 4 of 9, and you can file a request for post dating. And this post dating application, you can request for 1 month, 2 months. Maximum is limited to 6 months according to section 17. Whenever you are applying an application for post dating, the controller have maximum power to post dating for 6 months, section 17. And the form is form 30. We are already discussed form 30. Wherever a particular form is not defined, then you can use the common form. And for natural person, the fees is for electronic submission is 800, and others it is 4,000. Physical filing 10% extra, 880 or 4,400.
Excuse me, sir.
Yeah.
Which application is post-dated, provisional or complete specification we are post-dating?
You are post dating the provisional application. The reason is your complete specification is not ready on your expiry date. You want some more
Sir,
time to submit the complete specification. That is why you are post dating.
sir, in that case, we will lose the date of priority.
Prior, that is the risk also. I already mentioned that first January is your priority date. Suppose
Okay.
you are using maximum, then you can file a request for 6 months. Then your priority date may be 30th June, 6 months.
Okay, then
Then
that
the
will be the third.
advantage next year, for example, 2022 January is your priority date, 1st January 2022. 31/12/2022, you have to submit the complete specifications. But on 30th December, you are filing a request for post dating
Post-dating.
to avoid the action according to subsection 1 of section 9, abandonment. Then your priority date shall be post dated to 30th June 2022. Then only your expiry date shall be on 30th June 2023. Is it clear?
Yes.
Yeah.
Sir, one question.
Mm.
See, this thing, this post dating, I mean, you have already said, like, as per section 9(4), this is already there. So then why this is repeated in section 17 once again? I mean, is there any difference or it's same or?
There is no difference in Patent Act when our bill prepared. They are given controllers powers for different sections. We have so many
Okay,
sections like this, power of controllers, and
okay,
these are all relevant to that particular chapter. Subsequently, also related to different subjects, we have the similar sections, power of controllers. For example, anticipation, compulsory license. These are all, we are getting so many power of controller. Suppose you got a question related to a simple question like power of controller, you may be confused. But questions are preparing relevant to a particular section. Then only you can provide the answer, proper answer. Otherwise, you will be in trouble. And we will discuss that wherever the power of controller means that particular area, section or chapter. In this chapter, we have one more section is there. It's coming next section. Let us see. Powers of controller in cases of anticipation. Anticipation we are already discussed. Suppose you filed a patent specification, it is the duty of the examiner to conduct prior art search. Means he presume that your application may be in public domain. He is conducting search to anticipate your application is already in public domain or not. And this related to this, we have some more sections, 34, 32, 33, 34, so many, 29 to 34. We have several sections that we are not yet discussed. At that time, it may be clear. There is also another problem related to our act. Suppose we have a separate subject, anticipation, and all sections are not together. Suppose this section 13, 18, 29, 30, 31, 32, 34 are together. Suppose it is arranged in that way, it is very easy to understand. But unfortunately, it is in a different way. Okay. This is related to anticipation. And the previous is related to post dating, where it appears to the controller that the claimed invention is anticipated as per section 13(1) clause A or 13(2), he may refuse the application unless the applicant, generally, suppose your application is already anticipated, means your invention is already in public domain on or before your priority date, then he shall refuse your application according to section 15. A, subclause A, shows to the controller's satisfaction that the priority date of the claim of his complete specification is not later than the date on which the relevant document was published, or amends his complete specification to the controller's satisfaction. This clause may be clear only after discussing sections 29, 30, 31, 32 and 34. Suppose the facts and circumstances are relevant according to 29 to other sections, then you can amend your application and satisfy the controller. Then there may not be any anticipation. That we can discuss later. Okay. At that time, we will discuss 13 and 18 also when we discuss 29 to 34. And section 19 also says about powers of controller in case of potential infringement. Potential infringement, we already discussed, I think you are remembering about section 11. When we discussed the section 11, I give an example that 1st January somebody filed a provisional specification, and 1st March the competitor filed, and then the June another provisional is filed, and in September another application is filed. Accordingly, when the applications are examined, we find that some claims belongs to A, the first person who filed in January. For example, claims 1 to 5. And the subsequent applicant filed claims 1 to 15. I think you are recollecting that slide in your mind. And then the 16 to 30 claims belongs to Mr. A. Claims 1 to 5 and 16 to 30 belongs to Mr. A. Claims 6 to 15 belongs to Mr. B. That was our example. Suppose some case, in that particular case, this section is important. If it appears to the controller that an invention in respect of which an application for a patent has been made cannot be performed without substantial risk of infringement of a claim of any other patent, he may direct that a reference to that other patent be inserted in the applicant's complete specification by way of notice to the public, unless within such time as may be prescribed. The applicant shows to the controller's satisfaction that there are reasonable grounds for contesting the validity of the said claim of the other patent, or the complete specification is amended to the controller's satisfaction. Means, suppose the controller shall allowing the claims 1 to 5 and 16 to 30 to Mr. A. In that case, this section is applicable, and he had to direct the applicant Mr. A reference to that other patent be inserted in the applicant's complete specification by way of notice to the public. Means Mr. had to mention about the application, subsequent application filed by Mr. B, because the claims 6 to 15 belongs to Mr. B, and vice versa. When Mr. B's application is granted, at that time also, it is the duty of the controller to direct Mr. B to refer about the claims 1 to 5 and 16 to 30. The danger is, suppose you want to assign in your favor, or suppose you are applying for a license, then you may be in trouble. The public may be in trouble because some claims belongs to Mr. B, some claims belongs to Mr. A. That is why this provision. Is it clear? And next is powers of controller to make orders regarding substitution of applicants. Section 20. Any time before the grant of a patent, if the controller is satisfied on a claim made on and by virtue of an assignment or written agreement, he may direct the application shall proceed in the name of the claimant or claimants and the applicant or the other joint applicant or applicants accordingly. Form 6, Rule 34. Fees is 800 for individuals and 4,000 for others. Suppose Mr. A is the applicant. Inventor and application belongs to Mr. A. Suppose he is assigned to some company or some person, then there may be an assignment. In that case, you have to change the name of the applicant, or the inventor is no more, then you have to incorporate the legal heirs of the deceased inventor. That is why this section is providing one form. Any time
Sir, one
before, yeah,
sir, one question. What is substitution, sir?
you are
So
changing. You are changing. The substitution
okay,
means originally the applicant was Mr. A,
okay,
and Mr. A assigned his patent to, for example, Messrs. ABCD Private Limited Company. According to the assignment deed, the ownership is transmitted to Messrs. ABCD Private Limited Company. Now you want to substitute Mr. A in the place of ownership. Ownership is already transferred to a company. And now Mrs. ABCD Private Limited is the applicant. There is no change in inventor. I already mentioned when we compare the inventor and applicant, I already discussed that. Now section 20 says that any time before the grant of a patent, if the controller is satisfied on a claim made on and by virtue of an assignment or written agreement, he may direct that the application shall proceed in the name of the claimant, means the company or claimants, and the applicant or the other joint applicant or applicants accordingly. Means you can substitute the original applicant for the subsequent claimant. Claimant may be claim on the basis of assignment or agreement, whatever you are producing, according to the Patent Act. There are some complaints also that subsequently we will discuss that. Clear? Time for putting application in order for grant, section 21. An application for patent shall be deemed to have been abandoned unless the applicant has complied with all the requirements imposed on him within 6 months from the date of issuance of first examination report from the patent office. We are already discussed. Suppose you submitted a request for examination, then the controller shall forward the documents to an examiner for conducting your investigation and report to him. That is the procedure. Suppose the controller got the investigation report, immediately it is his duty to send the gist of the objections, if any, to the applicant. Then section 21 is applicable. An application for patent shall be deemed to have been abandoned unless the applicant has complied with all the requirements imposed on him within 6 months from the date of issuance of first examination report from the patent office. Suppose you received an FER on today, within 6 months, you had to submit the response for the same. Otherwise, your application shall be deemed to have withdrawn by yourself. The patent application shall be deemed to have been abandoned unless the applicant has complied with all the requirements. In India, 100% applications are getting FER. There may be so many objections. Objections in the sense you are not put the page number, there is no comma, some commas are there, so many things. Your claims are not properly drafted. These are all common. They will tick all the columns in the FER. In that case, within 6 months, you have to submit your response. If it is not done, your application shall deemed to have been abandoned. If you are not submitted the request of the application, your application shall be treated as withdrawn by yourself. That's the difference. Please note the difference. Suppose you are not submitted Form 18, request for examination, then your application shall be deemed to have been withdrawn by the applicant. Here it says, patent shall be deemed to have been abandoned. And this time may be extended for a period of 3 months. You have to submit Form 4, extension of time. Total time is available 9 months. Normal 6 months plus extension 3 months. Clear? And these sections, these are all deleted from our Act. There is no section 22, 23, 24, etc. Next is section 25. Opposition to the patent. Suppose somebody want to oppose the patent and invalidate the patent, you have a chance. And we have two types of opposition. One is known as pre-grant opposition and the other is known as post-grant opposition. But these two terms are not mentioned anywhere in the Act, commonly known as pre-grant opposition and post-grant opposition. Pre-grant opposition means an opposition filed before the grant of the patent. Post-grant opposition means you are submitting the opposition after grant of patent. And we have two sections. Subsection 1 of section 25 is related to pre-grant opposition and subsection 2 of section 25 is related to post-grant opposition. And everybody is saying this term, pre-grant opposition and post-grant opposition, but never mentioned anywhere in the Patent Act or rules. That is the interesting thing. Okay, let us see the definition. After the publication of an application, but before the grant of a patent, any person may, in writing, represent by way of opposition to the controller against the grant of patent. A patent application is published and you are very vigilant about the patents in India and you show one application and according to you it is not a patent, there is no legally it is not maintainable, then you can file an opposition to against the grant. But there are some conditions. First is the time. After the publication of your application, but before the grant of a patent. Within that period you can file application. Next is who is entitled. Any person may, you and me, everybody, in writing, represent. I think you are all familiar with the representation. A pre-grant opposition may be a representation. Represent by way of opposition to the control against the grant of patent. When application is published, I can even file an opposition on public interest, a representation before the controller. And form number is 7 capital A. No fees because it is public interest. The government is not charging any fees for this one. And before there was no form also. Form recently added. You can file a representation. That was the concept. And Rule 55 says representation under section 25(1) shall be filed at the appropriate office with a copy to the applicant and shall include a statement and evidence along with a request for hearing if so desired. Here there was a question, that's why I am saying that 1 plus 1, 2 copies you are submitted. Suppose you are filing physically, 2 copies are required. Online filing, a single copy is okay because the controller can transmit to the other party by email. There is no. But normally, according to the rules, 2 copies are required. And it shall include a statement. You have to write about your statement, who are you and why you are opposing it. And evidence along with their request for hearing. You have to submit evidence also. Along with the statement, you have to provide evidence and a request for hearing if so desired. Means when you are submitting it, if you want a hearing before the controller, request is mandatory. Otherwise, the controller can treat it as a representation. You can decide and dispose of your representation without hearing also. That is why Rule 55.1 says, if you want a hearing, you have to request it for the same. That is important for your viva. This type of question may be there. Next, Rule 1A. No patent shall be granted before the expiry of a period of 6 months from the date of publication under Section 11A. This is also provided because of the expedited route. I already explained that a patent shall be granted within 8 months in India according to the new expedited route. Suppose you are filing an application on 1st January, the same day you can file Form 9 for publication and 18 request for examination. Okay, same, the priority date, everything is same. Then what will be happening? Immediately within 30 days, your application shall be published because you paid the fees and submitted Form 9 for early publication. Normally, within 2 weeks, it shall be published. Then you are already filed a request also for expedited examination. Then next month, February, your application shall be examined. Immediately they will issue. If there is any response, the applicant is vigilant, then it is easy to grant. Then your publication maximum you can calculate 30th. 30th of January, your application is published. Submitted on 1st January, 30th your application published. Then according to Rule 55.1A, the controller shall wait for 6 months. Then January, then July, August it may be granted. If examination response is submitted immediately by the applicant, your application shall be granted in August.
Sir, can you repeat this 55.1A once more, sir?
55.1A says no
55.1A,
patent shall
yeah.
be granted before the expiry of a period of 6 months from the date of publication under Section 11A.
Okay.
In our example, an applicant is submitting an application on 1st January. Same day is submitted Form 9 for early publication and Form 18A request for expedited examination because you want to grant it as early as possible. You are ready to pay the money. Then normally your application shall be published within 30 days. Means on or 30th January, your application shall be published. And immediately your application shall be examined. Then you are also ready to provide all the response, etc. immediately. Then your application to grant, there is a restriction. 6 months you have to wait. Then only you can file a pre-grant opposition. Some time must be available for the general public to oppose the application. That is the intention behind Rule 55.1A. Means 6 months time is guaranteed by this rule for filing pre-grant opposition. No patent shall be granted before the expiry of a period of 6 months from the date of publication under Section 11A. Suppose in expedited route, somebody want to grant it within 4 months, you can grant a patent. To avoid that, there is some period is given for pre-grant opposition. Pre-grant opposition says after the publication of an application, means after January 30th. But before the grant of a patent, means August. The tentative date may be August. Within this period, you can file pre-grant opposition. But in normal case, normal application shall be published after 18 months. Then you are not filing any request for examination. You are filing in the 48th month only. Then your application may be examined after 4 years. Actually, somebody want to abuse this, that is also possible. In some cases, what the applicants are doing, they are filing a patent. They know intentionally that no, there may not be a chance of grant. Okay, you can file, and you can wait for 48 months for request for examination. Last day you are submitting, 4 years are over. Then you may get the examination within 1 year. Some case more than that. Then you are not filing any response to FER. 9 months time is there. Means you can abuse and keep, suppose you want to advertise, keep pending that patent pending for 6 or 7 years. And some departmental delay is there more than 10 years, 15 years also. I have an example that the 20th year one patent was granted in 2016. Okay. Next is post-grant opposition. Section 25(2). After the grant of patent, but before the expiry of a period of 1 year from the date of publication of grant of a patent, any interested person may give notice of opposition to the controller. The previous one before grant. That is why it is known as pre-grant opposition. Now subsection 2 says after the grant of patent, but before the expiry of a period of 1 year from, means after grant you have 1 year from the date of publication of grant of a patent. You are not aware about this. You are already aware about the section 11A publication. We have one more publication. That is according to 43(2). One more publication is there. Immediately after grant, your grant may be published. The patent grant shall publish. That is different publication. A patent is grant in the name of so and so and all details, documents. The register of public is also available in public domain. That is the advantage, the second publication. See, after the grant of a patent, but before the expiry of a period of 1 year from the date of publication of grant of a patent, any interested person may give notice of opposition to the controller. The words are very much important. In previous one, any interested person may. Here it says, give notice of opposition to the controller. What is the previous one? Any person in writing represent by way of a. Here it is used represent, means it is a representation. That is why there is no fees. Here it says any interested person may. Interested person means a person doing research in the same field. Suppose the invention is in a pharma field, a pharma company is filed a patent. Another pharma company is entitled to file a post-grant opposition. Give notice of opposition to the controller. Clear? The difference is clear for you?
No,
Yes,
sir. Sir, 20, there is a difference in the wording you said. So
Yeah.
25. So can you just come on that once more?
Yeah. Here time is okay. You can understand after the publication of an application, but before the grant of a patent. Any person may. Here, any person, you and me, everybody, in writing represent by way of opposition to the controller. You are writing a representation by way of opposition to the controller against the grant of patent. These are the difference. Here it says after the grant of a patent but before the expiry of a period of 1 year from the date of application of a grant of patent, any interested person may, means a person doing research in the same field, give notice of opposition to the controller. You are giving a notice. Legally, it is very strong, stronger than the other one. The reason is you are paying fees for opposition. You have to submit form 7. 2,400 is the fee for e-filing and 12,000 for others, and 2,600 for natural person and 13,200 for others for physical filing. Now it
But
is clear?
sir, the controller has to take cognizance of both, right? Even if it's a pre-grant opposition or a post-grant opposition, the
Yeah,
controller has to take the cognizance of both.
correct.
Then why is one stronger than the other?
Yeah, because the procedure is entirely different. This is on public
Because
interest.
one is notice and one is just representation. That's fine.
Yeah, it is a representation. Suppose you are not requested for hearing specifically, there may not be any hearing. Means the controller can dispose of your representation. And another
Oh,
thing,
so the controller can decide that it is not, he is not satisfied with the pre-grant opposition and he can dispose it off.
and one more thing, your application is not examined in this stage. See, after the publication of an application, but before the grant of a patent, anytime, means there may
Hmm.
not be any chance for examination. Means controller is not considered this whether it is eligible for a grant or not. That is also. But here, after the grant of a patent, means patent is already legally granted. Something serious.
Sir, and
Suppose
is this can the same person apply for pre-grant and post-grant? So say if somebody applies for pre-grant, it doesn't go through, then they wait for the grant of the patent and then they apply for post-grant.
and one more thing, we have one more section. At that time, you can realize that this is most
Revocation.
powerful. And suppose you are an interested person, you can avail both. You can file pre-grant and post-grant also. But if you are not an interested person, you have only one remedy. Being an individual, you can file a pre-grant opposition on public ground. But
What
when
is
a
the
patent is
implication, sir?
granted, only interested person is entitled to file the application. Clear?
So what is the implication then? Supposing I am already started manufacturing and then someone files a post grant, does that mean that whatever sales I have done, in case the opposition is found to be right, in
Yeah.
case the opposition is found to be right, then I have to share the profits with him or
No. The thing
something like
is,
that? No.
your patent shall be invalidated and everybody is entitled to manufacture the product. Suppose there is an infringement, there is no scope for infringement suit.
But then the onus of that is not on me, na, because I have already been granted the patent by the controller. So
But it
how am
is,
I?
according to me, according to my opposition, it is illegal. That is why I am filing a invalidation petition by way of opposition. I want to
But sir, the
invalidate your
applicant can
patent.
defend, right? But the
Pardon me?
applicant can defend his patent, right?
Yeah. You can also file appeal against this.
So, sir, so then, sir, I'll just continue on Nilesh's question
Hmm.
that what happens during the, I mean, the whole. So, let's say somebody files a post-grant opposition
Hmm.
and the proceedings are going on.
Yeah.
During that stage, what happens to the manufacturing activities?
You can proceed the manufacturing. There is no restriction for that. If there is any civil suit pending before the court of law. According to the court direction, you can continue or not. That is different thing. But generally, if prosecution is pending before the controller, there is no restriction for the production. You can produce it. And the benefit is for the infringer, your commutator. Suppose a possession is allowed, then patent shall be invalidated. Then everybody can make use of that invention.
Sir, what are the probabilities that such a thing can happen based on past situations?
There are so many examples. Even one of my student, he filed a pre-grant opposition when I was teaching for the LLB, this integrated 5-year LLB. What was happened? I give some assignment to my students, final year students, to file a pre-grant opposition. What happened was DRDO filed a patent that may be in 14 or 15, 2014 or 15. I'm remembering. That patent was published. 5 scientists are the inventors. They spent huge amount on R&D. It's a drug developed by our DRDO. What was happened in 2011? It was published in a scientific journal. My student conducted a search and he got the publication and he filed a pre-grant opposition, and the priority is already cancelled because it was already published by the same inventors. They are the authors. That is the advantage. Means several universities, several research scholars, what they are doing, without filing the patent, they are publishing their articles, journals. That too in well-known journals, and then it is very easy to locate by the examiner. If examiner is not noticed, general public can also file a pre-grant opposition. The difference between pre-grant and post-grant is clear.
Yeah.
Yeah, and the grounds for this we will discuss next class. We have several grounds for the section 25.1 and 25.2, but grounds are same. In 25.1, the same grounds are repeated in 25.2, and Monday we will discuss the grounds for opposition. Okay then.
Thank you,
Thank
sir.
you, sir.
Thank you.
Thank you. Good night.